Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Illinois. I am going to so enjoy doing this video, and I'll tell you why. Because I have done video after video after video talking about how rotten, how sinister, how nefarious your state government is. I have said time and time again that there is no state government that hates its citizens more than the state of Illinois. And every time you just think that it can't get any worse, well, they just never stop surprising you, do they? Well, the reason I'm going to enjoy doing this video is I'm going to talk about Illinois in an entirely different fashion. Now, if I did videos about the people I've met in Illinois, everything would be awesome. Because everyone that I've gotten to meet so far in the state of Illinois through this channel has been totally awesome. Totally looking forward to my road trip out there in May. But I have found a portion of your state government that, candidly, we should all be proud of. And as you know, one of the ways you can end up on this channel is to just do something that's so awesome, you deserve a big old attaboy. That's exactly what's going to happen, and it's going to happen today for the Illinois Sheriff's Association. So today, let's spend a few minutes and let's talk about when the sheriffs tell your attorney general to pound sand. Okay, Illinois, here's the case we're talking about today. We're talking about the case of Barnett v. Raoul, one of the many challenges to Illinois' horrifically unconstitutional assault weapon ban that the Seventh Circuit essentially wiped their rear with the plaintiff's argument on, and so apparently that is perfectly constitutional. There is now a petition, as we know, to the United States Supreme Court. I am proud to read some of these portions to it. This is an amicus brief. What's an amicus brief? For those of you who haven't geeked out on the channel long enough, that is a friend of the court. That is someone who is going to take sides, either supporting the plaintiff or the defendant, and file additional memorandum of authorities in furtherance of their argument. This is an amicus brief filed by the Illinois Sheriff's Association in support of the petitioners. That's right. The Illinois Sheriff's Association has filed a brief in support of Mr. Barnett. And I'm just going to get to reading some portions of it, some of the highlights on it, because this is a really succinct, well-written brief. But Illinois, listen, we knew about this map when they were passing the Protect Illinois Community Act. Apparently, a lot of your state sheriffs were willing to fight for your rights. And I want to tell you something that throughout the entire nation, I have found that the sheriff's departments all around the country take the protection of your constitutional rights just as seriously as they do policing the community and keeping the community safe. So you have a lot to be proud of with your sheriff's association, and when you hear what they put in this memorandum, you're going to be even more proud. The Illinois Sheriff's Association supports efforts to make Illinois and all of its citizens safe, but it also recognizes that those efforts must be within the bounds set by the Constitution. The Illinois legislature's HB 5471 crosses those bounds, and in doing so, demands that sheriffs enforce a law that deprives the law-abiding citizens they serve of their constitutional right to keep and bear arms for lawful purposes, including sport and self-defense. Because law enforcement should never be compelled to violate the constitutional rights of Illinois citizens, and because the Seventh Circuit Court of Appeals failed to recognize and follow the precedent set by this court less than 2 years ago, the ISA believes that petitioners have demonstrated that this case is an excellent vehicle for the court to reaffirm that it meant what it said in its prior ruling, recognizing the fundamental rights guaranteed by the Second Amendment. And that really is the theme behind this memorandum. They do a very good job of attacking all of the things that the Seventh Circuit did wrong. And that could be another 20-minute video in and of itself. But what they have done an excellent job here is emphasizing the fact that no sheriff in the state of Illinois should ever be placed in a position where they're having to enforce unconstitutional laws against their own citizens. The memorandum also states, despite the recency of this court's elucidation of the proper test, the Seventh Circuit's majority's decision failed to faithfully execute it. Incredibly, based on a misreading of Heller, the majority determined that more than 1,000 rifles, pistols, shotguns, and ammunition feeding devices covered by Illinois HB 5471 are not even arms that are presumptively protected as covered by the plain text of the Second Amendment. The majority has fashioned a new distinction for firearms that may be reserved for military use and for firearms the government puts in that category, giving the government a pass on justifying its regulation of those firearms. Nothing in the Second Amendment or this court's prior decisions supports such an outcome. And they go through on several occasions and point out the fallacy, and there were many, of the Seventh Circuit's rulings. But again, they're always willing to bring it back to, we do not want to be forced to enforce unconstitutional laws. As the frontline law enforcement in Illinois counties, the sheriffs represented by ISA are deeply vested in respect for the rule of law. As such, the ISA believes that allowing unconstitutional laws like HB 5471 to remain on the books for any extended period makes the execution of their duties significantly more difficult. And even if it were relevant to the constitutional analysis, crime data does not align with the popular narrative that such a ban on the acquisition and possession of the affected firearms and ammunition feeding devices will have an appreciable impact on public safety. And then systematically, the Sheriff's Association makes very cohesive arguments as to why the Seventh Circuit failed miserably in getting the ruling right, including the Seventh Circuit's decision cannot be squared with this court's precedent. And that is absolutely true. Also, the majority's refusal to recognize that the firearm and ammunition feeding devices banned by HB 5471 are arms demonstrates its determination to undermine this court's holdings. And that was perhaps one of the most offensive portions of the Seventh Circuit ruling is that, hey, none of these are even protected by the Second Amendment. The Sheriff's Association also points out the majority's reliance on dissimilar historical regulation undermines this court's holding. Also equally true, because when we're talking about gunpowder storage or Bowie knives, we're really kind of talking apples to oranges. But perhaps the most important point they make is this court's immediate intervention is required to avoid compelled enforcement of regulations that are facially unconstitutional. And in furtherance of that position, the Sheriff's Association very eloquently argues the sheriffs represented by the ISA unquestionably share a commitment to the rule of law in Illinois, but that rule of law starts first and foremost with the United States Constitution. In fact, sheriffs are required to take an oath prescribed in the Illinois Constitution that begins with an affirmation that I do solemnly swear that I will support the Constitution of the United States. Police officers across Illinois commonly take the same oath. And finally, the Sheriff's Association sums up their position as the frontline face of law enforcement for the citizens of Illinois, the sheriffs of Illinois embody respect for the rule of law. The majority opinion addressing HB 5471 undermines that rule because it diminishes this court's clear pronouncements regarding analysis of the Second Amendment issues. At a time when government institutions, including law enforcement, face increasing challenges to their legitimacy, this court should act promptly to reinforce the primacy of its rulings and reassert its analytical framework for Second Amendment issues. Well done, Illinois Sheriff's Association. Bravo. Kudos to you. The case once again is Barnett v. Raoul. We will link up the sheriff's brief down below so that you guys can geek out on it for yourself. Hey, Illinois, show your sheriff's departments out there a little bit of love. They are in your corner fighting like hell for your rights. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is also down there in the description box. And then finally, let's everybody remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. I'll see you guys all in May. Until next time, Illinois, thanks for watching. Stay safe.